Nearly 10 years ago, two Ontario teachers were keeping track of a fellow employee they had concerns with. And what happened next made it all the way to the Supreme Court of Canada. The principal at the school ended up seeing those notes on a laptop, and the Supreme Court ruled that the privacy rights of those teachers were violated in the process. What to many might seem like an ordinary case could have vast implications, according to a reporter with Canadian Affairs. Joining us now is that reporter, Meagan Gillmore. Meagan, thank you for joining us.
Thanks so much for having me.
Now, can you start by walking us through the specifics of this case?
Sure. So this all goes back to the 2014-2015 school year. And like you mentioned in the intro, there were some teachers, some grade 2 teachers at a school in the York region of Ontario who had concerns about the performance of some of their colleagues, just how things were going on the grade 2 team. So they spoke to their union, the Elementary Teachers Federation of Ontario, and the union told them, keep notes about this, which they did on a password protected Google Doc. Essentially what happened is one day, the principal of the school came into one of their classrooms after school to return like a piece of equipment. They noticed that the laptop was slow. The principal goes to turn the laptop off, and in moving the mouse, the screen lights up. He sees this document with all these notes, and he'd heard the teachers talking about these notes, or sorry, people had heard the teachers talking about the notes in the staff room. So he took some screenshots, and as a result, the teachers were disciplined. They received like a formal letter of discipline in 2015, and the union filed a grievance. So there was labor arbitration about this, and there was a judicial review. Then there was an Ontario Court of Appeal hearing, and then a final Supreme Court case. And it should just be noted that these formal letters of discipline were removed from the teachers' files years ago due to a sunset clause in their collective bargaining agreement. But the question of whether or not there was a violation of their privacy is still outstanding, and it's a greater question that goes beyond just their situation.
Now, we know that the court ruled in favor of the teachers in this case, but what was the argument for the principal, and why, in their view, was this not against a violation of privacy rights?
Sure. So I'm going to start with that second one about it being a violation of privacy rights. We're talking about Section 8 of the Charter of Rights and Freedoms about your right to not have things like seized. That question about whether or not there was a constitutional right was not raised in the labor arbitration. So the lawyers for the school board are saying that this was not supposed to turn into a case about charter rights. This was not what we were arguing at the beginning. And they would also say that what the principal was doing was just wanting to maintain good order at his workplace. How is this different from a manager at, say, a warehouse or any other place of business wanting to make sure that there is good order in the workplace? So first, there's the part that this was never originally a charter, and what makes what this principal did different from what any other manager in any other workplace does.
And why exactly is this case so important, and why could it have vast implications outside of just this example?
Sure. So the way this works is, if we're going to say the teachers' charter protected privacy rights were violated, that assumes that the Ontario Public School Boards are subject to the Canadian Charter of Rights and Freedoms. And for something to be subject to the charter, they have to be found to be what's called an agent of the government. So the Supreme Court has ruled in the past that, for example, universities are agents of the government. There's a lot of case law around how the charter applies to universities, but the Supreme Court had never ruled about if public school boards are agents of the government and thus subject to the charter. So what this ruling says is that Ontario public school boards are now subject to the charter and are agents of the government.
And on the topic of students, how could this ruling impact the privacy rights of students?
Yeah, we don't really know for sure yet. This decision just came out a couple weeks ago. It's summer break, schools aren't really in session right now. But some of the lawyers I spoke to when reporting on this did talk about how the next, in their view, the next logical implication or application of this case is, what about students at public schools? So this case looks at teachers at public schools. Okay, like that's understandable, but students are also part of it.